The battlefield has just shifted. The complaint filed by 2311 Racing and Front Row Motorsports against NASCAR is at the center of the storm, and two of the sport's most powerful voices, Rick Hendrick and Roger Penske, have now been drawn into the fray. The term huge changes is more than simply hyperbole. It is the only way to express what is happening. Let's begin with a bombshell. 2311 and Front Row have urged a federal court in North Carolina to compel Hendrick and Penske to take full depositions in person before NASCAR calls them to testify. The teams claim that these two owners were discreetly added to NASCAR's witness list months after the discovery deadline, and that when asked 3 times if they would testify, Hendrick and Penske reportedly responded no. What's with the sudden inclusion? It prompted charges of sandbagging. According to 2311 and Front Row, Mr. Hendrick and Mr. Penske's confidentiality concerns regarding their team's financial information do not warrant blocking plaintiffs from cross-examining them in open court on a pertinent topic. If they have a valid reason for moving to seal any of this information, they may do so subject to the severe procedures that the court applies when evaluating such a petition. They're saying, yes, these guys try to hide behind confidentiality, but that doesn't stop us from demanding complete transparency. And exactly what do they want to know? The motion addresses a wide range of issues, including the charter system, the 2025 charter renewal negotiations, the economics of team ownership, NASCAR's next-gen initiative, and Penske's ownership of the IndyCar series. A surprising portion of the article? As just one example, Mr. Hendrick's partner, Jeff Gordon, has stated publicly that, despite being one of the most successful and longest-running Cup Series teams, Hendrick Motorsports has not made a profit in 10 years. These are the most fundamental questions. Are Hendrick and Penske receiving preferential treatment under the charter system? Do they have better financial deals than other teams? Are they being paid by NASCAR in a way that exploits monopoly power? The motion even mentions how Hendrick is grandfathered into having 4 charters, whereas new teams can only have 3. It is claimed Hendrick Motorsports and Team Penske are paid more than other Cup Series teams based on the combination of a historical revenue allocation formula, and the fact that Hendrick Motorsports is allowed to have 4 chartered cars, as opposed to the typical 3, which gives them a better cost structure than other teams. And there's a hot claim. The reason there is no expense cap for Cup Series racing teams is because Hendrick and Penske prefer it that way. Scott Prime, a senior NASCAR executive, testified to this claim. So here you have 2311 and Front Row delving into the very foundation of NASCAR's power structure, claiming that if you've allied with NASCAR's governing family and received preferential treatment, you shouldn't be able to avoid tough questions. Even bigger, because Hendrick and Penske freely consented to testify on NASCAR's behalf, they can no longer say, hey, we're not involved, leave us alone. The paperwork contends, having made that voluntary decision, they have no basis to resist the scope of cross-examination and inquiry that all trial witnesses must face. On the opposite side, NASCAR responds. According to their petition, 2311 and Front Row are engaging in deception. Plaintiffs did not include Mr. Hendrick or Mr. Penske on their potential witness lists, so they cannot claim that any of their testimony is essential to plaintiff's case. In effect, NASCAR is saying, you didn't want us to call them earlier, so why are you surprised they showed up? Nor could plaintiffs claim that they must have access to additional financial information from Team Penske or Hendrick Motorsports, because plaintiffs never sought that information during discovery. And NASCAR clarifies their scope. They will not ask about income, expenses, profitability, employee salaries, or payments to drivers. So, at least in writing, they are reducing their own line of attack. The plaintiff's initial disclosure in January 2025 cited owners of NASCAR Cup Series race teams as potentially having pertinent information, refuting the claim of sandbagging. NASCAR identified Hendrick Motorsports and Team Penske as likely to have pertinent materials. Plaintiffs never requested a deposition. They did not object. They did not move to strike. In brief, NASCAR maintains it obeyed the rules and provided notice. The plaintiffs remained idle until late. Now let's look at the lawsuit from a broader perspective. Previously, 2311 and Front Row made a strategic pivot. They dismissed their Section 1 claim under the Sherman Antitrust Act, which deals with agreements between 2 or more parties to unjustly impede trade, and would instead focus solely on a Section 2 claim, monopolization by a single corporation. The filing spells it out. Defendants obtained a monopsony by purchasing the services of elite stock car racing teams. Defendants engaged in anti-competitive and exclusionary activities. The defendants acquired ISC to take control over Daytona International Speedway, Talladega Superspeedway, and Michigan International Speedway. Defendants removed a potential competitor by purchasing ARCA. The defendants unjustly maintained their monopoly by imposing non-competition covenants. Make no mistake, this is a blatant attack at NASCAR's dominance over the sport. 2311 and Front Row claim that NASCAR's control over charters, exclusivity relationships, team limits, and the new next-gen rules are all attempts to lock out competition, consolidate power, and hurt the teams that compete under its banner. The claims are not academic. They get to the heart of who controls who in Cup Series racing. Imagine yourself in the pit lane, watching high-speed automobiles pass by. You presume that the sport is free and fair, but what if the promoter owns or controls the tracks, signs exclusivity deals that restrict teams from racing elsewhere, forces teams to utilize new cars just for the series, and employs charter systems and income splits that benefit a select few while attempting to keep out potential challengers? That is the battleground that 2311 and Front Row claim they are looking at. Hendrick and Penske are no longer passive observers. They are targets, witnesses, and nodes in a power network. The issue isn't just about depositions and legal technicalities, it's about who has power in NASCAR, who profits, and if that authority is being used to lock out competitors and tighten the grasp of the few. What about the twist? Because Hendrick and Penske consented to testify for NASCAR, they gave 2311 and Front Row a golden ticket. More reason to dig deeper. The plaintiffs argue that cross-examination can now take place openly, eliminating the need for confidentiality. The trial is scheduled for December 1st, 2025, but what about this fresh motion? It's a significant adjustment. It transforms the players, it alters the stakes. What are the vibes? High tension, drama, and stakes. However, not everyone is prepared to step into the spotlight. Ricky Hendrick and Roger Penske, they are pushing back, hard. Their legal team has described what they regard as a full-fledged ambush. As they put it, movants find themselves quickly and without much warning in the unenviable position of being forced to give expansive and unnecessary deposition testimony as a result of wrangling between the parties to a lawsuit that should have settled long before now. Translation? They feel like pawns in a battle they didn't sign up for, and they aren't being quiet about it. Hendrick and Penske consented to give limited testimony, but only because of their decades-long connection with NASCAR president Jim France. That is all. Not because they wanted to take sides, not because they wanted to discuss their finances in public, and certainly not because they desired to be used as legal weapons by 2311 and Front Row. Interestingly, when NASCAR requested assistance, these two great owners agreed to certain terms, extremely specific conditions. Their lawyer, Adam Ross, claimed that France approached each of them individually, at the NASCAR awards ceremony no less, and asked whether they would testify about the high-level contents of the affidavits they filed weeks before. They agreed, but only under certain conditions. Hendrick and Penske wanted their testimony to be concise, high-level, non-confidential. What about now? 2311 and Front Row are encroaching more, much wider. According to Hendrick and Penske's counsel, the plaintiffs made it apparent that they want to request highly confidential business and financial records, private conversations concerning the original 2016 charter agreement, and other sensitive information. As they put it, plaintiffs refused and made clear that they intended to ask numerous questions of both men regarding their respective race teams' highly confidential business and financial records. This raises a lot of red flags for Hendrick and Penske. It contradicts a previous court decision from June, which prohibited non-party teams from disclosing financial information except in anonymous, untraceable form. The court acknowledged that the information was not only sensitive, but also harmful if disclosed. And now, Hendrick and Penske claim the plaintiffs are attempting to undermine that safeguard. Their motion concerns the possibility that the testimony that plaintiffs now seek will undermine the entirety of the court's decision and potentially allow the parties, or the media or general public, to reverse engineer the anonymized team information to back out HMS and PRS. In short, if Hendrick or Penske are compelled to address these deeper issues, the tightly guarded seclusion of the other teams may crumble. The timing couldn't be worse. Thanksgiving is right around the corner. The trial is weeks away. And now these two powerhouse owners are being hauled into full-fledged in-person grilling sessions, with lawyers keen to sift through every aspect of their operations. It's no surprise they're seeking to do this over Zoom and with stringent restrictions. Their organization describes it like way. HMS and PRS compete directly with NASCAR and plaintiffs for sponsors, staff, and on the track. Disclosure of HMS and PRS financial and operational information would thus be extremely costly and detrimental. They also state, rather plainly, that they do not believe a protective order will keep their secrets safe in court or from the media. This is not simply about risk, it's all about exposure. So we're left with two teams demanding complete accountability and two famous owners doing everything they can to minimize what they say. But, while the spotlight shifts between them, let us not forget what this case is actually about. This lawsuit is now solely focused on whether NASCAR has become a monopsony or a buyer with excessive market power. 2311 and Front Row contend that NASCAR controls the sport from top to bottom. They claim that the France family has locked up the most important racetracks, removed potential competitors, pushed teams into charter deals with limited flexibility, and created a wall around the next-gen car to prevent anyone from starting a competing series. They further accuse NASCAR of using the 2025 charter agreement as a threat, claiming that teams can only sign on if they commit not to sue NASCAR in the future. That's a hammer. Sign or lose your future. And for teams like 2311 and Front Row, this is more than simply pressure. It's monopolistic exploitation. They believe the France family and its close circle have rigged the system, not only to win, but to dominate the game. But here's the issue no one wants to ask, at least not publicly. If NASCAR has used its authority to favor a few hand-picked allies, are Hendrick and Penske part of that inner circle? If the answer is yes, then these two legends have benefited from special deals, higher payouts, and protected status while other teams struggle. Then this case is about more than simply money. It is about trust. Trust the system, believe in the fairness of the sport, trust that racing is more than simply entertainment for billionaires. So now everyone is waiting to see if the court will order Hendrick and Penske to disclose up. Will their secrets be used as ammunition in an unwanted war? Or will NASCAR's power system hold, surrounded by walls created over decades? Regardless, December 1st is quickly approaching. The courthouse is going to become the largest track in NASCAR. So here's a question for you. Should every team owner, no matter how wealthy, famous, or connected to NASCAR, be required to answer the same difficult questions? Or are we looking at a system in which the elite still compete under distinct rules? Please let me know in the comments this one isn't over, not even close.